Hello students, in this lecture number 3 on jurisprudence, I am going to discuss with you the definition of jurisprudence given by Holland. So what the definition of jurisprudence was given by Holland? Holland defined jurisprudence as the formal science of the positive law. That means to say, according to Holland, jurisprudence is the formal science which is concerned with the positive law. In the previous lecture, we have discussed the definition of jurisprudence given by the Austin, in which he made the classification of the jurisprudence into general and particular jurisprudence. But Holland criticized this division of jurisprudence into general and particular given by Austin because, according to Holland, as the jurisprudence is a formal science of the positive law, and like all sciences, jurisprudence must be general because the nature of the science is general. It cannot be particular to any particular area. So, according to Holland, jurisprudence is a formal science like all sciences. So, it must be general and cannot be particular. Holland pointed out that science of jurisprudence deals with the regulations of mankind. Which regulations of mankind are having legal consequences, but not with the rules which create those relations. For Holland, like Austin, jurisprudence is the concerned with the positive law. That means to say, according to Holland also, jurisprudence is concerned with the positive law made by the state. That means to say, according to Holland, jurisprudence is not concerned with the moral, ideal, or natural law. According to Holland, the study of jurisprudence is not concerned with the law as it ought to be in future, nor with the objects of the law, but with the law as it actually is. That means to say, according to Holland, the study of jurisprudence is concerned with the present law made by the state. It is not concerned with how the law should be made in the future. He further adds that in the study of jurisprudence, comparative law first of all collect the legal institution of various country and present it in tabulate form. Okay, and then set forth an orderly view of the ideas and methods which have been variously realized in actual system. I want to repeat it here. He further adds that comparative law collects and tabulates the legal institutions of various countries, and that jurisprudence set forth an orderly view of ideas and methods which have been variously realized in actual system. But there were number of criticisms to the definition of Holland. First of all, when Holland described jurisprudence as the formal science, then Holland's formal science itself was criticized by the later writers. They made the criticism of Holland's formal science on the ground that on what basis, on what ground Holland regards the jurisprudence as the formal science. He had not explained on what basis he regarded the jurisprudence as the formal science. One criticizer of Holland's definition was Salmond. Salmond also criticized Holland for his rejection of particular jurisprudence as was suggested by Austin. Salmond was in favor of Austin's particular jurisprudence, but it is very important to note here that Salmond was not in favor of Austin's general jurisprudence, whereas Holland was in favor of Austin's general jurisprudence, not particular jurisprudence. In his definition, Holland could not demark the boundaries of the subject properly. He did not demarcate that within what limit the study of jurisprudence is limited. So, in this way, we have discussed the definition of Holland. We have discussed to whom Holland made the criticisms, and we have also discussed in this lecture who made the criticism of Holland's definition. If you like my videos, then kindly subscribe my channel to get the new videos, and for notes on my lectures you can go to lawarticles2020.blogspot.com. Thank you very much.